as it pertained to drug trafficking. So Mr. Griffin is the one who initially claimed that he didn't know Mr. Green and ultimately admitted that they were drug dealing associates who had had a falling out. And the existence of both that relationship and the disagreement that they had serves to corroborate Mr. Santos' testimony and serves to establish the existence, beyond testimony from Mr. Santos, of that relationship and the reason for their involvement.
So is Santos going to testify before Griffin?
Yes, sir, that would be the plan.
I guess I'll hear what Mr. Santos has to say, and I'll review this and see how it fits together.
Yes, sir. Okay. The next one has to do with C.C. Timmons. I believe Ms. Timmons is being called by the defense, and I think one of the things they're going to elicit regarding Ms. Timmons is a letter that Brandy Peters had received from Mr. Santos. Last time that question was asked of Ms. Timmons, that piece of evidence was in evidence last time. This time we've done the previous aspect of the motion limiting for hearsay. As it relates to those particular letters, it is not in evidence at this point, and I would certainly argue that the letter, and I believe they're going to try and get that letter in through Ms. Timmons, that letter would in fact be still hearsay and inadmissible as it relates to that. Further, any reaction that she says that Mrs. Peters has to any of those letters would be pure speculational aspects on her part based upon conversation she's had with Brandy Peters, so it would also be based upon hearsay, all of which is in fact inadmissible.
Mr. Prince.
Once Mr. Santos
remind me what the sequence of events was, please. With Ms. Timmons.
Yes, sir. So there had been email communication, as the court probably recalls, between Mr. Santos and Brandy Peters. She received a letter, I believe it was
Ms. Peters
received a letter from Mr. Santos either the day of or the day before she was murdered. On the outside of the letter, it indicated, Mr. Mailman, if Brandy has moved on to heaven with her 3 little angels, forward this letter there. The contents of the letter were nonsensical code, as have all his letters to Ms. Peters, including the emails. But the purpose of the letters is not to prove whatever he is asserting within the letter itself. Number one, it's to corroborate Santos' claim about his relationship with Brandy, the fact that they knew each other and had contact with each other regularly. So even if it were being offered for the truth of the matter, which it's not, but if it were, I would submit that it would be admissible under Chambers for that reason, which is to say that it's corroborative of Santos and admissible under the 14th Amendment for due process reasons. Secondly, we don't intend to ask, was Ms. Peters scared? What did she tell you about how she felt? As we did last time, I would only seek to elicit her observations of Ms. Peters' demeanor upon reading the letter and bringing the letter across the street to show Ms. Timmons.
I'll access Ms. Timmons' prior testimony. We'll make you read that again. But you have it with you.
I have the copy of it, but it's all in the rest of it. I'll get it to you.
I can pull it up from there.
Yes, sir. And that, I guess, brings us to the final point, is even if Mr. Santos himself comes in and trying to admit those letters being Mr. Santos, it is still an out-of-court statement, and despite what Mr. Prince said, he is offering for the truth of the matter asserted. Those letters are for the purposes, as Mr. Prince just stated, is nonsensical code for this drug dealing aspect, and certainly he's going to be asking Mr. Santos about that. He's further going to be having Dela Cruz testify to that. Those letters are in fact being offered for the truth of the matter asserted therein, and that is this nonsensical code and the fact that there's a relationship between the two of them. They are out-of-court statements asserting those particular issues, and they are in fact hearsay and inadmissible. They are self-serving hearsay. Well, they're not self-serving, but they are statements offered for the truth of the matter asserted.
I'll read it if you're willing. Anything else?
I'll have a motion as it pertains to impeachment of Santos. I don't know if does the court want to hear that now? Or prior to Santos?
We can take it up now if you want.
Yes, sir. But I would move in limine to prevent the state from attempting to impeach Mr. Santos by suggesting that he's lied about involvement in other murders. I would suggest that that would be improper impeachment because you can't attempt to prove that a witness is lying about one thing by impeaching them with the fact that they may have lied about some unrelated thing. That is the definition of improper impeachment.
I'll overrule that objection. Santos coming forward to try to be the star in various situations, I think is extremely relevant. I'll overrule that objection. Anything else?
No, sir.
Okay. Anything else, Mr. Hughes?
No, Your Honor.
All right, we'll be in recess. That means it's going to be starting my computer here. Y'all can be at ease.